Welcome back to Courtroom Chronicles, where real justice gets real dramatic. Today, we're diving deep into the roller coaster case of State of Texas versus Xavier Dante Doxy, a saga that has it all. Arson, addiction battles, a revolving door of second chances, and a judge with more patience than a saint. Until she runs out, we'll meet Xavier, a man on the edge, facing 6 years for burning down a home, or was it a church, and repeatedly failing to follow the rules of probation. You'll see lawyers fighting for one last shot, state prosecutors who've heard it all before, and a judge forced to decide, can the system save someone who just can't seem to save himself? But here's where it gets spicy. What does it really take to get off the cycle of probation violations? Is the system failing Xavier, or is Xavier failing the system? And just when you think you know where it's going, the stakes rise. Will Xavier walk out a free man, or is this his last chance before years behind bars? Stick around as we break down the drama, decode the legalese, and ask you, the jury at home, to weigh in on every jaw-dropping twist. Let's get started.
Court is calling 2019 CR 9540 State of Texas versus Xavier Doxy. Can I have parties announced for the record for the state?
Lindsay Shaw for the state.
Lunch for Mr. Doxy.
Are you Mr. Doxy?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Xavier Dante Doxy who was placed on deferred adjudication in 2019 CR 9540 for the offense of arson of a habitation or place of assembly on December 13, 2019 for a term of 6 years?
Yes, ma'am.
State?
Violated condition number 5, Judge. In Bexar County, Texas, the defendant Xavier Dante Doxy did then and there fail to report to the supervision officer as directed for the months of October, November, and December 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
The second violated condition number 5, in Bexar County, Texas, the defendant Xavier Dante Doxy did then and there fail to report to the supervision officer as directed for the month of January 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True.
We'll waive all the remaining violations, Judge.
Any objections?
No objections.
Did you understand by pleading true to violations 5 and 5, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to 5 and 5?
Yes, ma'am.
Court will find 5 and 5 true. Is there an agreement?
No, Judge, there is not.
State, what are you requesting?
We're requesting, Judge, based on the results of the TAP that he completed.
Let's hit pause and break down what just happened. Xavier just admitted, twice, to violating his probation. In legal terms, that's like handing the judge a loaded cannon aimed at your own future. The court made it crystal clear. By pleading true to these violations, Xavier is now staring down the barrel of a possible life sentence and a $10,000 fine. But why does the system come down so hard? Because probation is a contract. Break it, and every prior mercy might get wiped away. Notice how the defense tries to pivot. He's got a more stable home now. He'll stay with his mom. But the state's not buying it, worried he'll just repeat his mistakes. Question for you. If you were the judge, would you gamble on giving him yet another chance? Or is it time to bring the hammer down? Drop your verdict in the comments.
In jail, they're recommending SATIF. So the state is requesting that he do SATIF. He was given he did complete ISF, and upon his release from ISF in March, leads to his failure to reporting, which he pled true to for October, November, December, and January of 2023. So the state's fear is that if he is granted something such as outpatient treatment and he's released from custody, the same thing is going to happen, and he's going to continue to fail to report and do what he's supposed to do on probation. So we're asking for SATIF.
And so, Judge, after the TAP evaluation, there was 2 recommendations. Obviously, is what the state has said is SATIF and also possibly inpatient therapy if the court were to consider it. The biggest difference now with Mr. Doxy is he has more of a stable living environment. He's going to be able to stay with his mom, which is at 5100 Eisenhower Road in San Antonio, Texas. 78218. Beforehand, after he was released from the facility, he was on the street. And he was using it, and he does recognize that there are some addiction issues. And I spoke to probation. They said it's about a 4 to 8 week wait for SADA. So we'd ask the court to consider an intensive outpatient. He does have more of a stable living environment, that he stays at that address that I provided to the court. And give him his last opportunity and hold SADA and hold it in advance.
All right, so the court began with outpatient treatment for your client. And so I'm going to follow the recommendations of probation. So I'll deny the motion to alter main conditions to include SADF. You can do a referral to felony drug court, see if they will accept him. If they accept him, then we'll transfer it to felony drug court. Otherwise, he's going to SADF, and he's to remain in custody until transfer either to SADF or felony drug court. Is there anything else?
No, ma'am.
All right, thank you.
Here comes a pivotal decision. The judge is playing chess, not checkers. She's denying the softer conditions and sending Xavier to either felony drug court or SAT, substance abuse treatment. Whichever will take him first. Why not just send him straight to prison? Because the legal system recognizes addiction as a driver of crime. The judge is trying to thread the needle, offer treatment, but keep the accountability high. But let's be real, after this many chances, is the system being too lenient? Or is it a sign of compassion for people battling real demons? Stick around, because the stakes only get higher from here.
Are y'all ready to proceed?
Yes, Your Honor. Yes, Judge.
Court is calling 2019 CR 9540, State of Texas versus Xavier Dante Doxy. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Robert Ramirez for Mr. Doxy, Your Honor.
Are you Mr. Doxy?
Yes, ma'am, I am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Xavier Dante Doxy who was placed on deferred adjudication in 2019 CR 9540 for the offense of arson with intent to damage a habitation or place of worship on December 13th, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 5 on or about the 12th day of March 2024 in Barrett County, Texas. The defendant Xavier Dante Doxy, defendant there, failed to conduct himself in a proper and orderly manner when reporting to the supervision officer at the Barrett County Community Supervision and Corrections Department in violation of condition number 5.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor. That is correct.
All right, is that the agreement?
That is, Your Honor. We would ask Your Honor for the honor to consider lifetime recovery. If that's possible.
All right, so in the motion to violation of condition number 5, what does that mean? How did he fail to conduct himself in an appropriate manner?
My understanding, Judge, is that in the justification, it states that he reported to be under the influence of amphetamines during an office visit.
All right. So has he been to safety before?
No, Your Honor.
All right, will he be accepted into safety?
He does have a history of drug use, Your Honor, marijuana and amphetamines. He did complete state ISS in December of 2021 or March of 2022. And he did complete SATA June of 2023 to October of 2023.
And I'm assuming felony drug court would not accept him because previously I ordered felony drug court.
He was not referred due to being in the static aftercare program, is what it says.
All right. I'm gonna give you a choice. Sometimes I can give people choices, sometimes I cannot. I do believe that you have a drug problem because everything that I see is related to your drug issues. I can sentence you to 6 years in the prison, or what I can do is I'll refer you to felony drug court. Maybe felony drug court will accept you because you're not in any other program, or either you're going to safety.
I'll take safety.
All right, so I'm going to deny the motion, alternate amend conditions. To include, the first thing I want is a referral to felony drug court. And then the second, if felony drug court doesn't accept him, then it'll be safety. And there's going to be the UA hotline upon release, and 120 sober meetings in 120 days. Why are you not able to stop using? What's going on? Do you have a support system? Do you not have a support system?
I have a support system now. That was
Now let's talk about support. The judge zeroes in. Why can't you stop using? Xavier admits he's only recently built a support system, his church family. But rewind a few minutes, and you'll hear his lawyer arguing he had no stable environment before. This is the heart of most probation failures. Without real-world support, even the best rehab program can fall apart. The judge's advice is gold. When you want to use, call someone. Call probation, call your sponsor, call me if you have to. Here's a question for our viewers. Do you think the court system does enough to connect people like Xavier to real, lasting support? Or is it setting them up to fail? Let us know below.
not implemented at first.
And who is your support system?
It's just a church family.
All right, your go-to should not always be to use drugs. I understand that sometimes they always say change people, places, and things, but when there's an issue, your automatic response should not be use drugs. If you're having an issue, your automatic response should be, okay, I think I'm gonna go on the path of losing drugs. Let me call my sponsor. Let me call probation. In this court, if you're thinking about using drugs, you know you're not supposed to use drugs. All you have to do is call probation, and if they're not responding, all you have to do is come into court, and you can come into court and say, Judge, I'm on probation out of your court. I'm struggling right now. I'm thinking about using drugs. And guess what? You'll receive help. But if you're just walking into probation, high on drugs, that's not a good look. Do you understand?
Yes, ma'am.
All right. Is there anything else that you need from the court to be successful?
Paper of from you to recruiter.
I'm sorry?
Think about trying to join the military, so like.
Oh, well, I don't want to step on anyone's dreams, but they may not accept you.
I understand that.
All right. But if you let probation know that's what you want to do, I'm sure they'll have a contact number. And I think if you Google, there's a 1-800 number you can call and you can see if they'll accept you. And because of the fact that it's felony drug court, I'm going to extend him for 2 years. All right. Anything else?
Okay.
But we're off the record. But yes, please do look into the military. Who knows? They may accept you. There was someone who spoke at the felony drug court graduation. He said that everybody told him, you can't be an attorney. You can't do this because of your history. Guess what? He graduated, and 4 years later, he's an attorney. All right?
Sure.
All right. Good luck to you.
Thank you.
Thank you, Your Honor.
You're welcome. Yes, he's the remaining custody. Oh, no, I need a break. I think, yeah, I need a break. Deputy Laura is looking at me with frowns. All right, court is calling 2019 CR 9540 State versus Xavier Dante Doxy. Could I have parties announced?
Megan Galloway for the state. Catherine Valenzuela for the defense.
And are you Mr. Doxy?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt? With your attorney, did you understand it?
Yes, ma'am.
Are you the same Xavier Dante Doxy who was placed on deferred adjudication in 2019 CR 9540 for the offense of arson intention to damage habitation or place of worship on December 13th, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 43 on or about the 14th day of May 2025 in Travis County, Texas. The defendant Xavier Dante Doxy did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, in that the defendant was unsuccessfully discharged from a residential outpatient treatment program in violation of condition number 43.
So to that violation, how do you plead? True or not true?
True.
And that is the only violation?
It is, Your Honor.
Okay. Did you understand by pleading true to violation of condition 43, the court could find it true, grant the motion, and sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 43?
Yes.
Court will find violation of condition number 43 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking for revocation and 8 years in the prison.
Okay, this is the moment where patience wears thin. Xavier's back, again, for his 5th probation violation. The state is done playing. They want him revoked and sent to prison for 8 years. Why so harsh? Because the legal system works on progressive sanctions. Each new violation means less mercy, more punishment. But here's the curveball. Defense says Xavier does great in programs. He just can't transition into real life. This is a classic dilemma in criminal justice. Recidivism isn't always about willpower. Sometimes it's about resources, mental health, and structure. What do you think? Should judges keep giving repeat offenders a shot? Or is there a point where enough is enough? Sound off in the comments.
This is the defendant's 5th MTR, and he's just failed to comply with his conditions of probation, and so that's why we're asking for what we are asking.
Why isn't he complying with conditions?
Here, for the court's clarification, that one of the recommendations from probation on that form was that he be placed in state ISF with the cognitive tracks. Yes, it's the fifth NPR. He has successfully completed all of the programs that have been inpatient. He's gone to ISF, he's gone to SAC.
So why didn't he successfully complete this?
I believe, Your Honor, and this is just preliminary, what I believe is that one, Mr. Doxy has not been evaluated for the mental health component when he was younger. He did have issues with ADHD. He did have issues in completing tasks. When we talked about it immediately, he said he knows he needs help. He knows that aftercare is the issue for him. He's very good at completing what we ask him to in a program, but it's the aftercare that's the problem. And so it's making better decisions, and that's why we're asking for the cognitive track.
All right, so here's the issue. I think everybody knew that there were mental health issues if you're trying to burn down a church. So that's a given. Everybody knew that there were some mental health issues. So that is why I had him evaluated for McBioff at the very beginning. This is his 5th MTR. There is nothing else the court feels that the court can do for him. It's his 5th MTR. And I understand probation's recommendation, but probation's recommendation for some people who've been missing for 4 years is continue. It's like, where's this person been?
Right.
So their recommendation, I do take it with a grain of salt, but I do internalize what they're recommending. But it's his 5th motion to revoke. There's nothing else. I don't think he's appropriate for probation.
And we understand that that would be difficult, and we talked about possibly working with the state and coming up with a number that would justify. I mean, he has roughly done 3 years in the course of treatment in inpatient and in jail, waiting to go to inpatient. And inpatient is not like, a walk in the park or a vacation. And I think he would like to address why he would like to stay on probation and what he feels like he would get out of probation and what he could do, if you would wish to hear that.
I mean, if he wants to present a testimony to the court, I'm always open-minded. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Xavier Dante Doxy.
All right. Do you just want to give a statement, or do you want to do question and answer, counsel?
I think he can give a statement where he discusses.
All right.
Basically, Your Honor, I feel like the leniency that's been shown from the court is very much appreciated. And I understand my flaws. I'm capable of understanding where I was wrong and where from another perspective, it doesn't look that good, but I know where I need help. I know where my strengths lie as well as my flaws. And I do believe with the cognitive track that more structure is the key here for me, if I do say so myself.
All right, so let me just tell you this. I'm internalizing what you're saying. Here's the issue. I know that sometimes
Did you catch that? Xavier's statement is raw honesty. He appreciates the court's leniency. He knows his own flaws, and he's begging for more structure. But the judge hits him with a truth bomb. I can't hold your hand forever. This is the real world of criminal justice. Judges aren't social workers, and there's only so many programs and staff to go around. Despite multiple tries, the court just doesn't have the manpower to monitor him for life. Here's a tough one for you. Should the justice system invest more in follow-up and case management? Or is it ultimately on the individual to stand up and change? Drop your thoughts below.
people do great when they have somebody in their life to tell them everything to do every day from the time you wake up and from the time you go to bed, right?
True.
But I don't have the manpower or the hours to do that. I don't have anybody from this court who can call you for the rest of your life to make you do certain things. So you had the first motion to revoke. You were continued. Second motion to revoke. You were continued. Third motion to revoke. You were continued. Fourth motion to revoke. You were continued. And now we are here on the fifth motion. There's just nothing left for the court to do. And each time that a motion to revoke was filed, each time whatever issue you were having, conditions were set to help you address that. Your attorney is saying that you need ISF. That would help you, the ISF cognitive. But you've already been given the MRT because the last attorney you were here with said the same thing, and the court addressed that with the programs and tools that I had to address that. And the MRT was to address that. So I just don't think you're a good candidate for probation. I wish there were more programs available where there could be a case manager automatically, somebody to check in on you at least once every 2 weeks or once a month, but I just don't have the manpower for that. So I don't believe that you're appropriate. But I will tell you this, I do appreciate your giving me some insight into you,
Yes, ma'am.
and that you understand where you've gone wrong. So his states you were requesting 5 years?
It's requesting 8 year.
All right, so you're requesting 8 years. So, probation, there any new cases or no?
Judge, I do not see any cases.
All right, the court is going to take into consideration everything that your client has with the mental health issues, the fact that we really don't have the programs or tools equipped to handle his issues. So I'm taking all of that in consideration when I give him his sentence. So I'm going to sentence him to 6 years in the prison, give him credit for any time served. There's to be no contact with Danielle Yorks, Yorks. All right, here's the thing. When you're released from custody, if you can't find a place to help you with your mental health issue, if I'm here, you can come back and address that with me.
Yes,
But I would stress to you that when you're released, the first thing you should do is go to Center for Healthcare Services, okay?
yes, ma'am.
All right, good luck to you.
Yes, ma'am.
Thank you.
Mayor, and just for clarification, the credit would also include inpatient programs that he could successfully.
Yes, I'll give him
completed?
credit for any successful inpatient treatment.
Thank you, Your Honor. We appreciate your consideration.
Thank you.
And there it is. The gavel falls. After years of chances, programs, and probation, Xavier Doxy is sentenced to 6 years in prison with credit for his time in treatment. The judge recognized his mental health struggles, but made it clear the court just isn't equipped to be his lifelong support team. This case is a tough look at the limits of the justice system when addiction and mental health collide with repeat crime. Did the judge make the right call? Was there anything else the system could have done? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Thanks for watching. See you in the next episode.